Texas's secret speech police are controlling campaign law. It's September 12th, 2024, and these are your headlines. The Texas Court of Criminal Appeals has ruled that the Texas Ethics Commission, often referred to as the state's secret speech police, must first review and investigate any complaints about campaign law violations before prosecutors can file criminal charges. Rather than duly elected officials having the power to prosecute these cases, the decision now places that power in the hands of an unelected bipartisan board consisting of half Republicans and half Democrats. The case in question involves Gail Charette, a Republican candidate who ran for county judge in Washington County in 2018. Charette was indicted on 4 misdemeanor charges related to alleged violations of campaign finance and election laws. These included accusations such as misrepresenting the source of a campaign communication and failing to file required financial disclosures. The charges were brought shortly before the 2018 primary election by a special prosecutor after the local district attorney recused himself. Reversing the lower court's decision, the Court of Criminal Appeals, which is Texas's highest criminal court, ruled that the TEC has exclusive jurisdiction over matters of campaign law violations. In the 6-3 ruling, the court stated that the TEC is the exclusive authority on investigating campaign law violations, and if they find sufficient evidence of wrongdoing, they can refer cases to prosecutors for criminal charges. In Charette's case, no such process occurred, and as a result, the court concluded that the trial court lacked the necessary jurisdiction to hear the case. Now, the 6-3 decision was authored by Judge Michelle Slaughter, who, along with 2 other judges on the court, was defeated in the Republican primary election earlier this year, largely due to their role in a 2021 decision that stripped the Attorney General of the power to unilaterally prosecute election fraud cases. In more legal news, the Texas Supreme Court has stayed a lower court ruling that prohibited the Tarrant County Republican Party from filling a contested precinct chair position while a Democrat activist's case against the party moves its way through the courts. This comes after an appeals court in Amarillo ruled that the local GOP could not fill the vacancy until the court resolved a related appeal. So, what's this all about? Well, during the March Republican primary election, Chris Rector won a Tarrant County precinct election against a write-in opponent. Precinct chairs are members of their county party's executive committee, which assist in governing the local party. However, Tarrant County Republican Party Chairman Beau French said that Rector was administratively ineligible for the position after discovering his affiliation with the Democrat Party. Rector ran as a Democrat candidate for both the Texas House of Representatives in 2022 and the U.S. House in 2024. It also made statements that he was only, quote, pretending to be a Republican and seeks to dissolve the Republican Party and ban Republican groups in Tarrant County. Well, in response, Rector decided to sue Beau French and the Tarrant County GOP. The lawsuit has gone to multiple courts, but the latest ruling from the Supreme Court stayed a decision by the Amarillo Court of Appeals. Effectively, this means that the Tarrant County GOP will be permitted to fill its vacant precinct chair seat without court interference. Yet, Rector's underlying contest in a related appeal over whether or not the party is entitled to attorney's fees remains pending.
America is at a crossroads. Now, more than ever, Texas must step up and lead the country. We don't have time to mess around. The only way to save America is with a strong Texas. You and I know this, but so do the enemies of life and liberty. Therefore, you and I have no choice but to stand up and fight. I'm Sarah Gonzalez, and to the enemies of liberty, I say, come and take it.
For a second time in 2 weeks, 2 Lubbock County commissioners skipped a meeting in order to block a property tax increase. Commissioners Jason Corley and Jordan Rackler intentionally missed Monday's Commissioners Court meeting in Lubbock, assuring that a quorum would not be present to vote on a budget and tax hike supported by the other 3 members of the body. State law requires a quorum of 4 Commissioners Court members to approve a tax levy. And the deadline to set a tax rate for the next fiscal year is coming up at September 30th. If Corley and Rackler break quorum one more time this month, the county tax rate will default to the no new revenue rate, which raises the same amount of revenue from the same properties taxed the previous year. Any rate above that is a tax increase. Corley and Rackler also avoided the last Commissioners Court meeting on August 26, siding with citizens opposed to the county's proposed property tax increase. For more of today's stories, go to TexasScorecard.com.